Okay, I agree with that. Response?
For this point, we'll let the reference continue to be used. However, I will give a limiting instruction to the jury that, they're to take it at face value.
So Ms. Hobson, as you're going into the death zone, how was Vanessa reacting?
Well, Vanessa she was clutching the armrest and she kept looking back saying, Danny, don't risk it, slow down. But Danny wasn't listening. He just went faster and faster.
So what did you do?
I yelled at Danny too. I told him to slow down.
And Ms. Hobson, I know this was a stressful night for you, but to your knowledge, did the defendant ever slow down? Did he ever brake?
No, the car just started sliding and swerving all over the road, but we never slowed down.
And what happened next?
The next thing that I remember is waking up in a hospital, and the first thing that I thought about was Vanessa. I didn't know where she was, so I turned to my parents and asked them, and that's when my mom just started crying, and that's when I knew.
Thank you, Ms. Hobson. No further questions, Your Honor.
Cross-examination? Counselor, step back a little bit, just be conscious of the witness's space.
You had a few drinks the night of the 23rd, right?
Yes, that's correct. I already told Vanessa that I was going to drink that night.
But it was hard to tell how many you had.
Well, I don't really know my limits, so no, I don't know how many.
At some point, you started to drink tea, right?
No, I didn't start drinking tea.
And Danny started to drink sodas.
He did say after a while that he would stop drinking so that he would be fine enough to drink.
But
I mean,
Danny did start drinking sodas after a while, correct?
yes, that's true.
Now, at the end of the evening, you questioned whether Danny could drive, right?
I did, yes.
But Vanessa said Danny was fine to drive.
Well, Vanessa was
Your Honor, hearsay?
It's in her affidavit, page 135.
All right, affidavits are not evidence, but don't worry about that aspect of it. Is this hearsay? Is it an out-of-court statement? Is it being offered in court?
Yes.
Is it being offered to prove the truth of the matter asserted in it?
No.
So, is it hearsay?
No.
And your response?
They're offering it for the truth of the matter that the defendant was fine to drive.
All right, I think they're just offering it as Ms. Sullivan's opinion, not necessarily for the truth. So I will allow it.
You were familiar with the way back to Vanessa's house, right?
I was, yes.
You directed Danny on Canyon Road.
Well, he wanted to avoid the cops, so we took that road.
You did direct Danny on Canyon Road, correct?
That's true, yes.
You know this is a dangerous road, right?
Yes.
2 people from your high school died on it, right?
That's true, yes.
The speed limit is 45 miles per hour, right?
Yes, that's true.
It's a very curvy road.
Yes, I would say so.
There's no lighting.
No.
And on that night, it was raining, correct?
Yes, I've already stated all of this.
During the drive, you were talking to Danny.
slow down, yes.
You yelled at him a few times?
That's true.
In fact, Danny told you that you were distracting him.
Yes, when I told him to slow down, he just turned the radio up and kept going.
You were distracting him, correct?
Well, I was telling him to slow down so that all three of us could make it back home safe.
But he told you.
But he told you that you were distracting him, correct?
That's true.
That night, you were in the back seat.
Yes,
It was raining hard, correct?
I've already stated that, yes it was.
And you didn't see anything on the road, correct?
No, there was nothing on the road.
But after that crash, Danny told you he saw something on the road.
Yes.
He said a deer ran onto the road.
Yes, he did say a deer ran onto the road, but I was watching the road and there wasn't anything there.
Since this happened, you have turned into a writer, correct?
Yes.
Objection, Your Honor, relevance?
We're just trying to prove the fact that she,
What, show bias?
no, we're just trying to prove the fact that,
Tax the credibility of the witness?
yeah.
All right. I don't see how the fact that she's a writer attacks the credibility of the witness, but I will give you a couple of questions to establish that, and if she doesn't establish that, renew your objection and then we'll strike the testimony. So for now, overruled.
You're at the Wash School of Journalism, correct?
Yes, that's true.
Where you learn how to tell stories, how to sell stories.
I learned how to write stories.
Well, you publish a short story, correct?
Probably in the future, yeah.
And eventually, you want to write a story about this case, correct?
Well, yes, it's a big part of my life, so I do plan on writing a story about it.
Thank you.
Redirect.
No, Your Honor.
All right, Sean, the T thing is straight out of your affidavit. At some point, it says that you know,
Stopped drinking
you were feeling
alcohol.
tipsy, and so you switched to tea, and Danny switched to sodas. And there was one other thing that was straight out of your affidavit. I don't remember what it was. The direct. Sad enough, I can't figure out what my note here is. I don't know. On the direct, you made an objection to a hearsay early on, and you were startlingly shot down. And as an attorney, I've been there, and it's intimidating. And it makes you slow to object throughout the rest of your time. But there were several things, such as, she made the statement, Danny wanted to avoid the cops. That's speculation. If she would have said Danny said he wanted to avoid the cops, well, that's a different issue, but she said Danny wanted to avoid the cops. She said Danny wasn't listening. Anything she says about somebody else's thought should instantly be, you should be starting to stand up for speculation. And then, she brought in some testimony by Vanessa. That's not an admission by a party opponent. Now, I don't know if they were all things that's true, I don't know, if it helps your side or hurts your side, but that would have definitely been a good ground for your objection. Grady, whatever introduction you guys use on your directs, just pick one and use all three, yeah.
And here's the one you pick. Tell us your name.
Or,
None of this, I don't ever want to hear the words "for the record"
yeah,
ever again.
no for the records and no spell your last name.
Yeah.
But either, please tell us your name, or the one I like is, please introduce yourself to the court. But no,
Please introduce yourself to the jury, if you got a jury.
all right. So, with that, Mr. Mays?
That's the first comment I had. Quit to spell your last name for the record. But we've done this for years and years and years, and that's why your team captains maybe have told you to do this, and it's because we've been doing it for forever and forever. We need to change it. The objection to the death zone, which I didn't want to respond to, Your Honor, the reason I made the objection is I'm screwing with them, but that was the reason I made the objection, because they said in their opening statement, I want to try to get that out so that I can, so that statement in the opening statement never came out into evidence, and that's why I made the objection. Also, my objection was a little bit long, was because I wanted to make sure y'all understood the objection. But we've got to have some way to get that in. It's technically inadmissible, I think. It's absolutely inadmissible, in my opinion, unless you can establish that the defendant knew that it was called a death zone. It's the state of mind of the defendant. I don't see the relevance of it, and I think that the danger of unfair prejudice will outweigh the probative value of it. As far as the Hobson Cross, okay, hearsay and out-of-court statement offered in court for the truth of the matter asserted therein. Attorneys, come see us later on. I don't want to go over it again. Come see us later on and try to hash over some of these statements, and we'll give you some examples as to how to get this stuff in. He told you, here's one, he told you you were distracting him. I think there was a speculation objection to, you were distracting him. There's a speculation objection to that one, wasn't it?
No, not for that.
Okay. He told you you were distracting him. That's hearsay. You objected that. I think that's all for the truth of the matter asserted. It's his state of mind, but he's stating something for the truth, or she's introducing something for the truth. That is, that he was distracted at the time. So I think that's, you could object hearsay as to that. And y'all on both sides, all the attorneys, what I want to, basically the main thing I want to say is on this, when you get an objection, when it's sustained against you, when it's overruled, whatever it is, you have the same expression on your face. Don't thank the judge, but it doesn't affect you, it doesn't harm you, no matter what the outcome of it is. Just keep your poise, keep the same demeanor, and don't, a lot of times you get, you have a tendency not to pull the trigger on an objection when you've been shot down a couple times. So don't feel like you can't object later on. All right, that's it.
All right, a couple of things. Shelby, at the beginning of the direct, you said the prosecution would like to call. Just try to catch that. Instead of would like to do anything, would like to offer evidence, just the prosecution calls or the prosecution offers an evidence, whatever. Just try not to say would like and so forth. And also, it's kind of nitpicky, but you began the direct with Miss Hobson, tell us your name, or Miss Hobson, introduce yourself. It just kind of sounds, the verbiage kind of sounds awkward, but and this is actually really good that I'm having to find nitpicky things to comment on. So you guys are way far ahead.
Doesn't help that you're third. Sorry.
Yeah, and plus I don't have anything else to say.
Okay.
And on the cross, I thought I had something to say about the cross. Maybe I. Oh, actually, one more thing. I'm not picking on you, Shelby, I swear, but you have a case of the ands. That's when you begin every question with and. Some judges, it just drives them crazy. I have the perfect remedy for it. If you see me afterward, it kind of gets violent, but we can. But as long as you're conscious of it throughout, it always gets better. So just be mindful of that. And everything else I have on the cross, it was good overall, but there are nitpicky things you can just kind of look at after we send these out. We'll talk about it. That's all I got.
Excellent job by the witness.
Yeah.
Except for learning your affidavit a little bit better. All right, next witness.
At this time, the prosecution calls Officer Ryan Foster.
Officer Foster.
May I proceed?
You may.
Please introduce yourself to the court.
Brian Foster.
Tell us about your education.
Well, I received my bachelor's in civil engineering from the Georgia Institute of Technology, and I received my professional engineering certification in 1999.
What do you do for a living?
I'm a patrol officer for the Midland State Police Department.
What are your duties as a patrol officer?
Well, I'm a patrol officer, and I'm also a member of the FCT unit.
What is the FCT unit?
FCT stands for Fatal Crash Team. What we do is we focus on accident reconstruction and determine the cause of fatal accidents.
Are you qualified to be a member of that team?
Yes, I am.
How?
Well, I attended the standard 22-week training at Midland State Police Academy. I earned my professional engineering certification. I've taken numerous seminars in road design and safety, and I've also received a specific certification in 2004 by the Traffic Accident Reconstruction Team.
Specifically, how are you involved in this case?
Well, on the night of September 24, 2010, I received a call saying that there was a fatal accident. So me being a member of the FCT, I was called.
Did you ever respond to the scene?
I did. I arrived 2 to 3 minutes later.
Tell us what you saw when you arrived at the scene.
Well, when I first got there, the driver was standing outside. He was apologizing profusely, but I still saw 2 passengers that were on the inside.
Now, you said the driver was apologizing profusely. Did you ever identify this individual?
Yes, I did. I later identified him to be Danny Dawson.
And after that, you said you heard passengers inside the vehicle. Did you ever check on these passengers?
Yes, I did.
What'd you find?
Well, in the back seat, who I later identified was Taylor Hobson. She had visible signs of injuries. I saw blood on her hands and forehead. And in the front seat, I knew to be Vanessa Sullivan.
Tell us about Vanessa Sullivan.
Well, she was still strapped in her seatbelt, but she was unresponsive. So I tried to see if she was alive still. But while I did that, the EMTs came behind me.
Well, what did you do at that point?
Well, I directed them immediately to Vanessa because she was unresponsive.
After you directed the EMTs towards Vanessa, what did you do?
I started approaching Danny Dawson.
And what happened?
He had said something about needing another drink.
Objection, Honor, hearsay.
Under 801D2, this is an admission by a party opponent. By definition, this is not hearsay.
Overruled.
You mentioned the defendant said something that evening. Could you repeat that for us?
He said something about he needed another drink.
Well, after the defendant mentioned needing another drink, what did you do?
I began to prepare to administer a sobriety test.
How do you prepare to administer a field sobriety test?
First, I called the station to see if someone would be there to administer the test. And secondly, I read the defendant's rights.
Why did you read the defendant his rights? Were you going to arrest him?
Not immediately. I was going to ask the defendant if he was drunk, so I wanted him to be aware of his rights if he did say yes.
After you read the defendant his rights and called down to the station, what did you do?
I confirmed that someone was there to do the test, and then I began administering the field sobriety test.
How do you administer a field sobriety test?
I give him the standard 3-battery test, which is an HDN-I test, the split attention test, and the balance test.
You said these are standard tests. Why are these standard?
Well, those are the 3 tests that the State Department has established to be the most reliable and accurate when determining if one is intoxicated or not.
Have you ever administered these tests, these standard tests, before?
Yes, of course. I've interpreted and administered them hundreds of times under state guidelines.
Specifically, which test did you administer to the defendant?
On that night, I first gave him the HDN-I test, then the balance test, and then the split attention test.
What were the results of these tests?
Mr. Dawson failed all 3 of them.
After the defendant failed all 3 field sobriety tests, what did you do?
I called down to the station and had made sure Dr. Avery was there to administer the test once I released him.
Did you have any other interaction with the defendant after you took him to the station?
No, sir, I did not.
Now, did you have any other involvement in this case?
I did not.
Are you sure?
Besides the FCT reconstruction analysis.
Tell us about the FCT reconstruction and analysis.
Well, what I did is I was the lead investigator in the FCT analysis. So we reconstructed the accident to find out what was the cause of it.
Have you ever done this before?
Yes, I have.
When you perform an analysis, do you record your data in any way?
I do.
How?
We form a report.
Would you recognize a copy of that report if I showed it to you in court?
Yes, I would.
I'm showing the opposing counsel what has been pre-marked as prosecution 1. May I approach the witness?
You may.
Showing the witness that same document. What is this, Officer Foster?
This is my report,
And how do you know it to be that document?
because I created and wrote it.
Does this appear to be a fair and accurate copy of your report?
It does, yes.
Now, as a member of the FCT squad, is it a regular part of your business to make these reports?
Yes, it is.
Was this specific report created during the normal course of an investigation?
Yes, it was.
You keep a record of this report?
I do.
And did you make this report at or near the time you performed your analysis?
Yes, I did.
Now, at this time, prosecution offers Exhibit 1 into evidence.
No objection, Your Honor.
Are you sure?
Now that you say so. Objection to hearsay.
All right, your response?
Under 8036, this is an exception to hearsay as a record of regularly conducted business activity.
Are there any